Hey everybody, we are back in the Shanty. I took a nice long vacation, which I haven't done in years and years and years. Thank you, DeAndre and Allison, for covering for me while I was gone. I appreciate it very much. But I'm back. Didn't want to come back. No, I'm kidding. I'm back, and it's a beautiful day in the Shanty. The sun is shining. There's a little haze from the wildfires, I think. But the sun is shining and it's nice and warm, and it's going to get really hot and muggy this afternoon. And when it does, we'll flip on the air conditioning. But we're back. So what are we going to talk about today now that I'm back? I'm going to tell you all about my vacation. No, I'm not going to do that at all. Suffice it to say it was wonderful. What I'm going to talk about today is non-competes, because when I left, or before I left, I was getting a lot of calls. People were asking about, hey, what's going on with non-compete agreements? And the reason for that is we were seeing a lot of things in the news about covenants not to compete, and were they going to still be enforceable, and is there going to be federal action on them? Is there going to be state action on them? What's going on with covenants not to compete? So I thought I would do a little kind of where are we now and where could we be going, Shanty, on covenants not to compete. So let's do that. We're going to start with where we are now. All right. First of all, the first thing you need to know is traditionally, covenants not to compete have been a creature of state law. So each state has different rules and different laws regarding when a covenant not to compete is enforceable, if it's enforceable, and when it's not. And if you're a multi-state employer, that that can be a bit of a hassle, because the covenant not to compete in Michigan might be enforceable, and they generally are with certain conditions that we'll talk about. But say our friends in California, for example, covenants not to compete are generally speaking not enforceable ever. Now, not always ever. There's an exception. It's a sale of business exception. But generally speaking, for an employee that's not an owner, in California, you can't get a restrictive covenant. They're not enforceable. So what's the law in Michigan? Well, in California, there's a statute that prohibits these things. In Michigan, there's a statute that allows them, that actually allows them. And it's MCL 445.774A. So I'm going to read a minute, okay? So if I look away, that's why. Forgive me for not having memorized this statute. Here's what the statute in Michigan says. An employer may obtain from an employee an agreement or covenant which protects an employer's reasonable competitive business interest. That's important. See, my hand went up. I'm an Italian. I punctuate with my hands. Reasonable competitive business interest, and expressly prohibits an employee from engaging in employment or a line of business after termination of employment if the agreement or covenant is, quote, reasonable as to its duration, geographical area, and the type of employment or line of business, end quote. And the statute goes on to say, to the extent any such agreement or covenant is found to be unreasonable in any respect, a court may limit the agreement to render it reasonable in light of the circumstances in which it was made, and specifically enforce the agreement as limited, period, end quote. Now that last part is pretty unusual. Generally speaking, courts won't rewrite your contracts for you. But this statute actually allows a court to do that. Not void the contract, but rewrite it to make it reasonable. Now, we put language in the contracts, in the covenants not to compete that I write, there's language in there that says the court will do that just to be safe. But the statute actually allows it here in Michigan. So there's 4 things in that statute that we really have to focus on. So let's talk about those things. What does it mean? And issue number 1, and one of the things that often gets forgotten, is in order for a covenant not to compete to be reasonable, you must have a reasonable competitive business interest that you're trying to protect. So what is a reasonable competitive business interest? There's lots of case law in Michigan that has dealt with that issue. What is a reasonable competitive business interest? And the courts have said it's things like protecting goodwill, protecting customer relationships, protecting your confidential information, protecting your trade secrets, things like that. Those are the things that you're trying to protect. So you got to start there to determine if under Michigan law, your covenant not to compete is going to be valid. Because if you don't have a legitimate business interest that you're trying to protect, the covenant on its face isn't going to be valid. Give me an example, Palazzo. All right, let me give you an example. Let's say you have everybody in your company sign a covenant not to compete, including, say, I don't know, your janitor. What reasonable business interest are you seeking to protect by having your janitor sign a covenant not to compete? Do they have any access to your customers or your confidential information or your trade secrets? Is it access you couldn't protect with another agreement? They certainly don't have access to your goodwill, generally speaking. I mean, every employee affects your goodwill to some degree, but come on, be reasonable. So if you're asking a janitor to sign a covenant not to compete, you might have a hard time. Now, if you're asking your CEO to sign a covenant not to compete, it's way easier to prove those things, right? So we start there, a reasonable competitive business interest. So what's the next thing a covenant has to be in Michigan to be enforceable? Well, it has to be reasonable as to its duration. And again, duration, this is a moving target, all right? So if you're selling your business, for example, and you want the person, let me flip that around. If you're buying a business, for example, and you want the person who you're buying the business from to not compete with you after they're gone, after you've bought the business, which makes complete sense. I don't want to spend a lot of money buying a business and then have the person who started the business turn around and start a new one and compete with me. I just paid them a lot of money for this. The length of the covenant not to compete can be much longer. For example, up to 5 years, the courts have held. And in some cases could be even longer than that. And that makes complete sense. As a matter of fact, all of the stuff that we're going to talk about, and even our friends in California, have that exception to their covenant not to compete rules. If you're buying a business or selling a business, you can be subject to a covenant not to compete, and it will be enforceable, even if some of these other ones are. If you're not selling your business, let's just say we want an employee to sign a covenant not to compete. Again, it's going to be a function of what does that employee do for you and how can they hurt you by going out and competing. And that's going to determine the length. But generally speaking, we're looking at something like 6 months to a year for most employers. Anything longer than that, the courts are probably going to have trouble enforcing that. Okay, that's duration. What about geographic scope? How wide, how broad can the covenant not to compete be? Again, it's a function of your business and who you're asking to sign the agreement. There is no bright line rule. Michigan courts have, for example, found, quote, an unlimited geographical scope is reasonable if the plaintiff's business is sufficiently national and international in scope, period, end quote. Often what you do, let's say, for example, you've got a salesperson and their territory is Michigan, Ohio, and Indiana. Often what you do in a situation like that is you have a covenant not to compete that covers Michigan, Ohio, and Indiana. Asking them not to compete in the entire United States, where they have no contact, say, in Texas, might be unreasonable. What business interests are you protecting? How is the scope of that reasonable? And then the last thing you have to do is what is the type of employment or line of business that we're talking about? And generally speaking, we're talking about type of employment. A CEO is a CEO. We don't want you to go to the competitor and be a CEO. You can go to the competitor and be a janitor, but you can't go to the competitor and be a CEO. And by the way, you can't go to the competitor and have a title that says janitor when you're really the CEO. Okay? So that's what we're talking about there. So that's the rules of Michigan right now. That's the law. So what's going on in Michigan that would affect that? Well, there's a bill in the House of Representatives of Michigan right now. And remember, we have a very employee-friendly Congress in Michigan right now, legislature, and we have a very employee-friendly governor in Michigan right now. So House Bill 4399 was introduced on April 12, 2023 of this year. And what it's going to do is it's going to place restrictions on when a covenant not to compete is enforceable and when it's not, if it's passed and signed by the governor. The first thing it does is it modifies that language we talked about at the beginning, and it says the following, quote, I'm going to read again. Subject to this section, an employer may obtain from an employee a non-compete agreement that protects the employer's reasonable competitive business interest and expressly prohibits an employee from engaging in employment or a line of business after termination of employment if the agreement is reasonable as to its duration, geographical scope, and the type of employment or line of business, period, end quote. Now, if you're really sharp, you'll notice that that's not that big a change from what we already talked about the law being. It takes out the words or covenant and just makes it a non-compete agreement. So you'd have to have a written agreement. There's not going to be any covenants tucked someplace else or anything like that. You're going to have a specific agreement. But it's basically the same. So what's the big deal? Well, that's not all the bill does. That's what's the big deal is. It has other restrictions in it. And here's where we start getting into the other restrictions. The first thing it does is it places 3 requirements on you in order for the agreement on its face to be enforceable. You've got to do, there's 3 preconditions that you as an employer have to meet to make this thing enforceable to begin with. First, the bill says, an employer shall not obtain a non-compete agreement from an employee or applicant for employment unless the employer has done all of the following. Number 1, provide each applicant for the position with written notice of the requirement for a non-compete agreement. In other words, we've got to tell you up front, to get this job, you have to sign a non-compete. All right? Got to tell you up front. 2, before we hire you, we have to give you the non-compete. Before we hire you, we have to give you the non-compete so you can review it and look at it. You have to have it in your hand so you know what the written terms of the agreement are. And number 3, you have to post the law in with the rest of your postings. So those are 3 preconditions for having an enforceable covenant not to compete if this thing passes. And there's more. The other thing you can't do under this new bill is you cannot ask what's called a, quote, low-wage employee, end quote, to sign a covenant not to compete. Quote, an employer shall not request or obtain a non-compete agreement from an employee or applicant for employment who is or would be hired as a low-wage employee. So who's a low-wage employee? Well, there's a definition. A low-wage employee means one of 2 things. Number 1, it's a minor. You can't ask anybody under 18 to sign a covenant not to compete. Now look, you can't ask them. You can ask a minor to sign one of these things now, but they're not enforceable against a minor. So again, that's not that big. And how many of you are asking 16-year-olds to sign covenants not to compete? Probably not many. But number 2, an employee, as defined by 29 U.S.C. 2003, who receives annual wages from the employer at a rate that is less than 138% of the last published federal poverty line for a family of 3 individuals. Now that seems like a great big deal. So now we've got a dollar amount under which we're not allowed to ask for a covenant not to compete. But it probably isn't as big a deal as it seems, because I went and checked. What is the current federal poverty line for a family of 3? And according to the website, the federal website, it's $24,860. 138% of that, if I did the math right, don't count on it, is $34,306.80. That's pretty low. And my guess is not a lot of you have people making less than 35 grand signing covenants not to compete anyway. It's usually your higher wage employees that are being asked to sign this. So is that big a deal? Maybe not. But that's not all. Of course that's not all. The bill has some other stuff in it. In addition, all of the following are void and unenforceable, according to the bill. Number 1, a non-compete agreement obtained in violation of sections 2 or 3 above, which are the sections we just talked about. That makes sense. Number 2, an agreement that purports to waive the requirements of this section. Okay, so no waiving the law. Can't have an employee say, hey, I get it, I understand what the law is, don't worry about it, I'll waive my rights. No waiving the law. And number 3, you cannot have a choice of law provision in an agreement to the extent that it would negate the requirements of the statute. In other words, okay, the law stinks in Michigan now, we don't like it, so we'll choose Delaware law, for example. That choice of law provision in a covenant not to compete will be deemed unenforceable, and Michigan law is going to apply for a Michigan employee in Michigan. All right. In addition, the bill puts the burden of proof on the employer to prove that the employee is not a low-wage earner. Shouldn't be that hard. You've got a W-2 somewhere. And if the courts void or limit the non-compete, the court shall award both of the following. To the employee and any other injured party, the actual costs of the action that were necessary to defend against enforcement of the non-compete or to void or limit the agreement, including but not limited to reasonable attorney fees. There we go. We got reasonable attorney fees again. Excuse me. Plaintiffs' lawyers love reasonable attorney fees provisions in these statutes. It makes them much more likely to sue because they think they can get their fees out of it. And to the employee, all income lost as a result of the actual or threatened enforcement of the void non-compete agreement or the unreasonable terms of the non-compete agreement. So you're paying the employee if they're sitting on the sidelines while we're trying to enforce the agreement. So that's what's going on in Michigan. So where is this thing now? Well, it's a bill. It's only a bill, and it's sitting there on Capitol Hill. Takes me back to my youth. You know that, right? You guys know what I'm talking about, right? You might not. I'm very old. So it's just a bill, and it's been referred to committee. But we've got a legislature that has shown a proclivity this year for moving very quickly on legislation that it deems to be employee-friendly. This is clearly employee-friendly, although it's not that bad a bill, generally speaking. It is still employee-friendly. And the legislature, if they get their hands on this, is likely to pass it or something even more restrictive. And the governor's likely to sign it. She's already said she doesn't like non-competes. All right, so what's going on at the federal level? That's the state. What's going on at the federal level? Well, we have to start with the fact that President Biden doesn't like non-competes. He campaigned against non-competes. He issued President Obama didn't like non-competes. He issued a state call to action on non-compete agreements, asking the states to make them illegal. And apparently the states didn't move fast enough for President Biden, because President Biden has now put non-competes square in his sights, and he's going after them. But he's not the only one. Congress is moving on this too. So on February 1 of 2023, 3 Congress people, 1 Republican and 2 Democrats, introduced a bill they're calling the Workforce Mobility Act that will significantly limit the use of non-competes, and similar legislation has been introduced in the United States Senate, there by 2 Republicans and 2 Democrats. That's not a lot of co-sponsors, so, nothing happens in Congress, so nothing might happen to this. But let's talk briefly about what the bills would do. First, they would narrow the use of non-competes for only necessary instances of a dissolution of a partnership or the sale of a business. In other words, they would be invalid in every other case. The bill directs the Federal Trade Commission and the Department of Labor to enforce the law, and it empowers state attorneys general to enforce the law at the state level, and provides a private right of action for individuals to sue under the bill. And it requires employers to make their employees aware of the limitations on non-competes. As the bill says, quote, as studies have found that non-competes are often used even when they are illegal or unenforceable. I don't believe that, but that's what the bill says, okay? So that's what's going on in Congress. Now, where's this going to go? Probably nowhere. Nothing happens in Congress, ever, it seems. So, the president has directed his executive agencies to go after non-competes, and they're doing just that, primarily 2 of them. The first is the Federal Trade Commission. So back on January 5th, 2023, the FTC released a notice of proposed rulemaking to prohibit employers from imposing non-compete clauses on workers. In other words, they want to pass a rule, a regulation, that prohibits non-competes. The FTC is seeking public comment on the rule, with all the proposed comments being due 60 days after publication. If the rule is put in place, compliance with the rules is required 180 days after final publication. No effective date of the rules has been proposed. The earliest it might become effective would be September of this year. We're coming up on that. But here are some of the proposed highlights of that rule, that proposed rule, or some of the highlights of that proposed rule. The rule would apply to expressly named non-compete clauses, as well as, quote, de facto, unquote, non-compete agreements, which have the effect of prohibiting competition and employment, including broad non-disclosure and confidentiality clauses, and clauses that would require an employee who resigns within a certain period of time to pay a former employee for training costs not reasonably related to costs incurred by the employer in training the worker. That's really broad. Don't like that at all. Now, the rule doesn't specifically address non-solicit agreements, and it doesn't prohibit them, provided that they are very, very narrowly tailored and don't prohibit competing employment. The next thing the rule does is it says for existing non-compete agreements, in addition to requiring the employer to rescind the clause, rescind the non-compete agreement, you actually have to go out and provide individualized notice to all your current and former employees whose clauses have been rescinded. The only stated exception to the rule for non-compete clauses in the rule is the sale of business or sale of an ownership interest in a company, as long as the person owns at least 25% of the business. And the rule would preempt all inconsistent state laws. In other words, we'd have one federal rule for everything. The comment period ended on April 19th. So why am I brushing over so fast? The thing was 100 pages long, over 100 pages long, the proposed rule. I'm brushing over it because I don't think it's going anywhere. Do I think the rule is going to be passed? Yep. Or put in effect? Yep, I do. Do I think the FTC will come out with a rule and publish it in the Federal Register? Yep, I do. Do I think the minute they do that, somebody's going to sue the FTC? Yep, I do. And they're going to sue in a very conservative court. We've seen this tactic over and over. Lately, the court of choice for this sort of thing is a federal district court in Texas. And once it gets to the courts, it generally gets enjoined pending the outcome of the suit. And eventually it will end up in front of the Supreme Court of the United States. And just last year, the Supreme Court of the United States told the Environmental Protection Agency, who had also tried to do an end run around years and years of settled legal precedent with some rulemaking, you don't have the authority to do that, and I don't think the FTC has the authority to do this either. Okay? So that's what's going on at the FTC. What else? Well, we've got the National Labor Relations Act, their board, of course. And the National Labor Relations Board, through their general counsel, is once again sticking their nose into something that is none of their business. And on May 30th, 2023, the NLRB General Counsel issued a GC memo to all regional directors, blah, 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 setting forth her view that, quote, the proffer, she loves that word, proffer, that means handing something to, giving something to somebody, giving it to them. The proper maintenance and enforcement of non-compete provisions in employment contracts and severance agreements violates the National Labor Relations Act, except in limited circumstances, period, end quote. Basically what the GC memo says is, quote, this is what the GC says, non-compete provisions reasonably tend to chill employees in the exercise of Section 7 rights when the provisions could reasonably be construed by employees to deny them the ability to quit or change jobs by cutting off their access to other employment opportunities they are qualified for based on their experience, aptitudes, and preference as to the type and location of work, end quote. Now, in my humble opinion, this is stretching Title VII way beyond what it was ever intended to do. Non-compete agreements have been around for a long, long time. Section 7 has been around for a long, long time. To say that this is a creative use of Section 7 is generous. So with all of this going on, what do we do now? Nothing. The law in Michigan right now is that covenants not to compete, as long as they meet all of the things we talked about, are valid and enforceable. And that's been the law in Michigan for a long, long, long time. Now, when you are deciding whether you want someone new to sign a covenant not to compete, you should be thinking about those four things under Michigan law. Your competitive business interest and what you're trying to protect, the scope, the geographic scope, the time scope, and the line of business or the type of work. You should be thinking about those things. But you don't have to run out and void all your covenants not to compete. They're still enforceable in Michigan right now. Now, we're going to keep an eye on all this stuff and see what happens. We're going to keep an eye on all this stuff and see what happens. And we'll keep you up to speed on what's going on. So the best thing I can tell you right now is if you have any questions about any of this, give us a call. And we will make sure that you get the answers you need. This is a long one. It's great being back. Talk to you later.